Hello again. My name is Frederik Harhoff. I'm Professor Emeritus in International Law at the University of Southern Denmark. Last time we spoke a bit about the law of the sea, and today we will have a look at the use of force in international law. You may all resort to or consult the UN Treaty Article 2.4, in which it says that states are not allowed to use armed force against the territorial integrity or political independence of any other state. That's the main rule. It establishes that the use of armed force against another state whereby you violate the territorial integrity or the political independence of a state is forbidden, strictly forbidden under international law. So this is clearly the main rule. The only exceptions we have is three exceptions. There are three exceptions to this rule. The first exception is if the United Nations Security Council sanctions the use of force, that is to say, allows the use of force, allows member states to use armed force against the state that is violating international law, so as to bring the conflict to an end. The typical example is if a state is engaged in a civil war or in a war with another state, and the invading state is committing a lot of war crimes or violating international law, and every attempt to bring the conflict to a peaceful solution have failed. And so in the end, the United Nations Security Council may try and stop the conflict by issuing a resolution that is issued under Chapter 7 of the United Nations Charter, which allows the Security Council to issue resolutions that are immediately legally binding on all subjects of international law. We don't have a legislative authority in international law, but we do have this one particular example of an international body that is able to hand down rules that are immediately binding on all international legal subjects, all states. And that is the only example of such a legislative authority that is given to the Security Council. So it's only if international peace and security has come under threat and severe violations of international humanitarian law are being committed, there's a human crisis. In that case, the Security Council may be convened and may adopt a resolution that orders the parties to immediately stop the fighting. And if that does not happen, then in the end, the Security Council can allow other states to interfere in the conflict with use of armed force in order to bring the conflict to an end, to a stop. It has happened a few times, but in normal cases, the UN Security Council will deploy a peacekeeping mission. That is to say, they will send in soldiers that come from the member states. They will put together a UN force, peacekeeping force, consisting of soldiers from Denmark, from France, from all over the country, and under the leadership of one general, the officer of the peacekeeping force. And the peacekeeping force will then enter the territory of conflict and try to separate the parts so as to avoid further atrocities, and so also in particular to assist the civilian population and all the victims of the conflict. If that doesn't help, then the UN Security Council can sharpen the mandate a bit and authorize the peacekeeping force to use whatever force is necessary in order to obtain and to perform, to fulfill its mandate, namely to keep peace. So if it is necessary for the peacekeeping force to carry out its mandate and to keep peace, then the Security Council can authorize that peacekeeping force to use limited armed force so as to stop the conflict between the warring parties. This has also happened a few times. It is important to note, though, that when the Security Council deploys an international peacekeeping force into a country, they wear these blue helmets, and they are often called the blue helmets. When the blue helmets come in, they are not part of the conflict. So they are not allowed to use armed force in order to take side up with one of the warring parties. They should stay neutral. And it is only in the instance that we have just discussed or just mentioned, namely if the Security Council finds it necessary to allow the peacekeeping forces, they are peacekeeping, they're not peace enforcing, allow those forces to use limited amounts of armed force in order to stop the fighting, then they can do so. Now, the UN Security Council is composed of 15 members, 5 of which are the permanent 5 members of the country, China, Russia, England, France, and the Soviet Union. And the United States. And so each of these 5 permanent members of the Security Council have the right to issue a veto. So it is only, the Security Council is only able to establish a peacekeeping UN force to be deployed to a conflict area to stop the conflict if none of the 5 permanent members issue a veto. If they do that, then it's not possible for the Security Council to deploy anything to the conflict area. Then they will have by other means to try and settle the conflict, for instance, by calling for negotiations or otherwise pressuring the parties to stop the conflict. So, exception number 1, authorization from the Security Council to use armed force against the state. Example number 2, or exception number 2, is the use of force in self-defense that we have also touched upon in the last session. But if a state is attacked by another state, then of course that state has the right to fight back and use armed force against the attacking state. That will be completely lawful, of course. But the purpose of the use of armed force in self-defense only goes so far as to stop the conflict. So once the attacked state, by using the right of force in self-defense, is using armed force against the attacking state, and the conflict has actually stopped, the war has ended, the attack has been fought back, then the attacked state must stop there. It cannot pursue and launch a new war against the attacking state. And that also applies where the Security Council then takes over the control of the conflict, which it will by its resolutions. So when the Security Council declares that now we are taking over, once the conflict has come to an end, the war has stopped, then the country that has used armed force in self-defense has to pull out, draw back, and then from that point on, it is the responsibility of the Security Council to ensure that things go on peacefully from now on. The third example, which is not quite accepted, and I don't think that we can really call it an example, that's humanitarian intervention. There's doubts about what humanitarian intervention really means, but humanitarian intervention by most people are understood to be interventions in which the Security Council has been unable to intervene in the conflict. And so a number of states are then they're tempted to use armed force in order to stop the conflict because the atrocities are so horrendous that the international community cannot just sit back and do nothing. If the Security Council is unable to act because of the veto, then the international community sometimes thinks that it has the right to intervene, and that is to say to deploy armed forces and stop the conflict. However, humanitarian intervention is not accepted as a lawful reason, but many wish to have it accepted, but at the moment the majority of international legal scholars think that it is not accepted, and the reason is that it is too tempting for other states to use humanitarian intervention as a pretext for entering a country. The last exemption is what we call responsibility to protect, or abbreviated into R2P. This was a Canadian construction suggested in the United Nations a couple of years back. And the idea is, in the R2P text that was adopted at the World Conference, was that states must be reminded of their duty to keep and protect international peace and security. And so all states have a duty to do whatever they can to intervene, not militarily, but politically or diplomatically, into a conflict to try to bring the conflict to an end, if it is a conflict. So the R2P resolution, first of all, goes to the core point, namely states must be reminded of their obligation to, all of them, try and preserve international peace and security. If that fails, then states have an obligation to come to the assistance of the states that are involved in the conflict. So now we're not only talking about polite diplomatic attempts to bring the conflict to an end. Now states have a further obligation to actually go in and intervene politically, or not politically, but diplomatically, to see if they can offer their services, if there is anything they can do to help bring the conflict to an end. Is there any service they can offer? Can they bring anything to make it easier for the warring parties to stop the conflict? And so that's the second step of the R2P resolution. The third and the last step is that then states might be called upon to use armed force, just like a humanitarian intervention. But in the R2P resolution, the last step, namely the use of armed force against the warring parties, or the aggressive party, can only take place if the Security Council so allows. So that is meant to be another means of pressure on the Security Council, and in particular the 5 members of the Security Council, one of which might veto, to put pressure on that vetoing country to say, come on, you may have your own reasons to veto a humanitarian intervention, but listen, we think very seriously that you should abandon that position, and you should allow a humanitarian intervention to take place, in this case, for the benefit of humankind. Thank you so much.